Hello, and welcome to the COVID-19 webinar, What Executive Leadership and HR Professionals Need to Know. I am Marlene Laro, a partner and the COO of Potomac Law. As many of you know, Potomac Law is a new model law firm with over 100 lawyers in 18 states. Since our founding in 2011, we have been fully cloud-based with a distributed workforce, all working remotely. As such, our model enabled us to continue working in the same manner as we did before the global health crisis. We are a full-service law firm with a range of practice areas from corporate to litigation to IP. Today, I am pleased to present 4 partners from the Employment and Human Resources Practice Group. The presenters will explore 4 primary topics and then move on to take your questions. We have already received some questions in advance, and please feel free to send questions during this webinar in the chat function. Any comments or questions written in the chat will only be visible to my colleagues, the panelists. We will begin with Catherine Gutman-McCabe. Catherine has been with PLG for 6 years. She's a partner in the firm's Employment and Human Resources Practice Group and is a founding member of the firm's Education Practice Group. Over the past 25 years, she has served as in-house and outside counsel for flagship universities, private educational institutions, associations, and education technology innovators. She advises on a wide range of workplace matters and conducts internal investigations, compliance reviews, and training. Today, she will be addressing the Families First Coronavirus Response Act and leave laws. With that, I turn to Catherine.
Thank you, Marlene. Good afternoon. We're very happy you could join us for this webinar. I'm going to start off with a discussion of the Families First Coronavirus Response Act, the FFCRA, which provides 2 types of federal leave related to COVID-19: emergency paid sick leave and expanded family and medical leave. Both types of leave are limited to the time frame April 1st to December 31st, 2020. There's a lot of detail in the FFCRA, and the Department of Labor recently issued regulations which are already the subject of litigation. I'm happy to answer questions during the webinar or afterwards if you would like to contact me. So there are 3 important components of each type of leave. When can the leave be taken? How much leave can be taken? And how much of the leave is paid? First, when can the leave be taken? Emergency paid sick leave has 6 qualifying reasons. 3 of those relate to the employee's own condition, 2 relate to the employee's need to care for someone else, and the last gives the Secretary of Health and Human Services flexibility to respond to changing conditions. An employee's own condition exists in 3 circumstances. 1, the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. 2, the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. Or 3, the employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis from a healthcare provider. The next 2 reasons address the need to care for someone else. When the employee is caring for an individual who is subject to a quarantine or isolation order, or the employee is caring for his or her son or daughter whose school or place of care is closed or unavailable for reasons related to COVID-19. The last reason, as I said, is when the employee has a substantially similar condition as specified by the Secretary of Health and Human Services through the operational period of April 1st through December 31st. So again, that was a summary of the 6 qualifying reasons for emergency paid sick leave. Expanded family and medical leave has 1 qualifying reason: the need to care for a son or daughter because school is closed or childcare is unavailable due to COVID-19. This reason is, of course, in addition to the other qualifying reasons that already exist under the FMLA. So now, how much leave can be taken? Emergency paid sick leave provides 80 hours or 2 weeks of leave. Expanded family and medical leave provides 12 weeks of leave. A part-time employee is eligible for leave based on the number of hours that the employee is normally scheduled to work over that period. So now we're at our third important concept, how much is paid. It's important to note that leave payments under the FFCRA are dollar for dollar reimbursed to the employer through a refundable tax credit. Emergency paid sick leave is paid at the employee's regular rate of pay at the highest applicable minimum wage, with a cap of $511 a day or $5,110 total, where the need for the leave is based on the employee's own condition. So again, that's when the employee is unable to work because the employee is subject to a quarantine or isolation order and or experiencing COVID-19 symptoms and seeking a medical diagnosis. Alternatively, emergency paid sick leave is paid at 2/3 the employee's regular rate of pay or the highest applicable minimum wage, with a cap of $200 a day and $2,000 total, where the employee is unable to work because of a need to care for an individual subject to a quarantine or isolation order, or to care for a child whose school or childcare provider is closed or unavailable for reasons related to COVID-19. For expanded family and medical leave, the first 2 weeks are unpaid, but the employee can use emergency paid sick leave or other paid leave. The next 10 weeks are paid at 2/3 the employee's regular rate of pay or the highest applicable minimum wage, with a cap again of $200 a day and $10,000 total. An employer must maintain the employee's coverage under any group health plan during the period of leave. The employee remains responsible for paying his or her portion of group health care premiums. When an employee needs to care for a child because school is closed or childcare is absent, then the employee will qualify for both emergency paid sick leave and expanded family and medical leave. These leaves run concurrently, and the total expanded family and medical leave cannot exceed 12 weeks. Emergency paid sick leave is in the aggregate and does not exceed 80 hours. And the emergency paid sick leave is in addition to any paid leave provided by the employer prior to April 1st, 2020. So now that we've covered what the FFCRA leave is, let's look at the applicability of the law. The law applies to private sector employers, both for-profit and nonprofit, with fewer than 500 employees in the United States. There is a limited exemption for a small business with fewer than 50 employees if providing paid sick leave and expanded family and medical leave is to care for a child, and if it will jeopardize the viability of the business as a going concern. All employees of a covered employer are eligible for emergency paid sick leave regardless of length of employment, but an employee must have been employed for 30 calendar days in order to qualify for expanded family and medical leave. Also note that healthcare providers and emergency responders may not be eligible for paid sick leave or expanded family and medical leave on a case-by-case basis. There are several other key components of the law. Employers may not discharge, discipline, or otherwise discriminate against any employee who lawfully takes paid sick leave or expanded family and medical leave under the FFCRA. Retaliation is also prohibited. Employees generally have a right to job restoration after they take leave, although there are some exceptions. Note that an employee is not protected from employment actions such as layoffs that would have affected the employee regardless of whether he or she took leave. Enforcement of the laws is the same as that under the FLSA and FMLA as applicable. Note that an eligible employee may file a private right of action to enforce expanded family and medical leave only if the employer is otherwise subject to the FMLA in the absence of expanded family and medical leave. It's also important to note that managers and supervisors may be sued in their individual capacity. The Wage and Hour Division has posted on its website a standard notice related to the FFCRA. The notice must be posted in a conspicuous place and can be emailed or mailed to employees, or the employer can post it on an internal or external website. Even those organizations that claim an exemption must post the notice. And so now I will turn it back over to Marlene, who will introduce the next panelist.
Yes, thanks, Catherine. So next, we have Isaac Mamaski. Isaac is a partner in the Employment and Human Resources Practice Group. He provides insightful strategic business advice to management teams and in-house attorneys across a variety of industries. Like the other panelists, Isaac is also a member of the firm's COVID-19 resource team. During this challenging time, he's been advising clients on the unique legal challenges raised by the pandemic, including issues related to the Paycheck Protection Program, expanded unemployment compensation, and other recent federal relief efforts, with a specific focus on how they intersect with various employment law considerations. Isaac will provide you with updates from the EEOC, including pandemic preparedness in the workplace and the Americans with Disabilities Act. Isaac?
Thank you very much, Marlene. It's really amazing to me to think how quickly the world is changing in these very challenging times. Back in March, the governor of Ohio made national headlines by telling employers across the state to check their employees' temperatures. Many saw this as a radical measure at the time, and it was really, it created a lot of buzz. Fast forward just a few weeks, and we are now seeing headlines such as temperature checks, the new normal, right? So it's just amazing how quickly things change. So whenever employers conduct health screenings or otherwise make decisions based on their employees' health, the Americans with Disabilities Act becomes a key consideration. The ADA, it regulates medical examinations conducted by employers, the medical questions employers can ask their employees, and of course, it regulates accommodations for employees with disabilities under certain circumstances. So the Equal Employment Opportunity Commission has issued fairly extensive guidance for employers to help navigate ADA considerations during the pandemic. And I'd like to briefly discuss some of the key takeaways with all of you today. So first of all, employers should not ask employees questions related to disabilities. So employers should not ask if an employee has a compromised immune system or if they have a medical condition that makes them more likely to contract COVID-19. Employers can ask questions about symptoms of COVID-19, in an effort to ensure that sick employees stay home. Likewise, if an employee calls you, they say, I'm sick, I can't come in today. The employer is absolutely allowed to ask them questions about what their symptoms are in order to protect all the other employees, and if they were exposed to someone with COVID, which we'll touch on a little later, to inform them. Now, of course, if you have an employee who's working from home anyway, if they call out sick, you should not ask them about COVID symptoms because they're not coming in, they're not exposing other people. So this only applies for the moment to the essential employees who are actually coming into the workplace. Next, and we have already received some questions about this prior to the webinar, so just to briefly address it. Employers can check temperatures. This was our starting point from Ohio to today, where this is becoming the new normal. Employers can check temperatures. They can administer COVID tests, and they can conduct COVID screenings of current employees and of new employees, but only after making a conditional job offer. Now, what if an employee refuses your COVID screening? You tell the employee, we're going to take your temperature, they say no. You say to the employee, I would like to ask you some questions about any symptoms of COVID that you may or may not have. They say, I will not answer your questions. What can you do? First of all, you can bar the employee. The EEOC specifically says you can bar the employee from entering the workplace. But they make another preliminary recommendation. They say first, you should assure the employee that their medical information will remain 100% confidential. And they say that if the employee is told that their information will remain confidential, it makes the employee much more likely to say, fine, you can take my temperature, I'll answer your questions. Now, of course, any records resulting from medical screenings should be maintained in a separate medical file, not as part of the employee's personnel file, and they should be treated as confidential medical records. Likewise, if you send an employee home, the decision should be kept completely confidential. Now, you can tell, not can, you should tell other employees that they were exposed to a coworker with COVID, but you should not identify who that coworker is. You should not use their name. Of course, if you were in a small workplace, if you were an employer of just a few employees and they all know each other, if you tell one of them, hey, one of your coworkers, right, was sent home with COVID, but I can't tell you their name, the employees will know who it is. But the EEOC specifically says, do not confirm. Even in that situation where it's obvious, and an employee says to you, well, it was John, wasn't it? You should say, look, I can't answer confidential personnel questions, but I can tell you you've been exposed to someone with COVID. So perhaps strange, guy. I mean, it makes sense, but a strange thing to do under the circumstances. So the information should be shared on a need-to-know basis. I will just sort of, before moving on, I will mention one thing. A key person with a need to know is a member of management who will interview the sick employee to determine who they've been in contact with. So an employee tells you, I have COVID, I can't come into work, right? You say, great, feel better, stay home. But then the next question is, and who have you been in contact with? And whoever conducts that discussion, whoever conducts that interview absolutely has a need to know the name of the employee and the details that they've shared with you. And by the way, one other point, if an employee is working from home because of COVID, you can share with other employees, of course, this employee is working from home. You should not share with them the reason the employee is working from home, again, due to confidentiality. Okay, moving on. So now, the EEOC tells us you can delay start dates for employees who have COVID. So if you make a conditional job offer, you determine an employee is sick, delay their start date. But let's say you need the employee to start right now, immediately, right? You need someone to start right now, maybe not the person who you initially hired. The EEOC says you are allowed to withdraw a job offer if you need someone to start immediately and an employee has COVID. Now, of course, if employees were exposed to someone who has COVID, you can have those employees stay home for 14 days and quarantine. You can request that any employee who's been exposed to a person with COVID, not necessarily a coworker, someone out of the workplace, that they stay home. If an employee has traveled to an affected area where COVID is highly, where many people have it, that person can also be instructed to stay home for some kind of quarantine period. Now, before allowing a sick employee to return to work, you are allowed to request a doctor's clearance saying this person can safely return, this person is no longer sick. The CDC, however, does advise that if someone calls out sick, you don't request a doctor's note. And the reason for that is you don't want to dissuade employees from staying home. If they're sick, you want them home, you don't want them coming in. If you tell employees you must have a doctor's note to show that you're sick and only then will we allow you to stay home, then you are inviting sick employees to come into the workplace, and that's something we want to avoid. Also, the EEOC makes very clear, employers can require infection control practices. You can tell all your employees, you can't shake hands, you have to stand 6 feet apart, you must wear masks, you must wear gloves, you must wash your hands every hour, whatever those procedures are in your workplace, you are absolutely allowed to enforce those. Now note, many mayors and many governors have issued executive orders saying that employees in their state must wear masks or they must wear gloves. And many of them have further said, and these things must be paid for by the employer. That's not universally the case. In some states, the employees can bring their own protective equipment, or they have to bring their own protective equipment. So you should check in your particular state to see who has to provide that. I will just conclude with one final point. For the moment, much of this guidance applies obviously to essential businesses, to supermarkets, to transportation companies, to entities that are open now despite all the stay-at-home orders. Many quote unquote non-essential businesses, they aspire to reopen as soon as possible. They want to, obviously, they want to open for business again as soon as they can. The exact timeline for now is still unclear as to when many businesses can open. It obviously varies depending on their location, depending on their state. But we can safely assume, based on guidance we've seen from various public health experts and from various states, that employers will reopen while COVID is still an active concern, but not on the same level that it is today. So the question becomes, which of your employees might not be able to come to work once you reopen because of COVID concerns? And one place that we started from is saying that you cannot ask employees about disabilities. You cannot say to them who has a compromised immune system, right? Who is most likely to get sick from COVID? So, you're unlikely to come to the workplace when we open, but maybe you can come 2 months later. Here's what the EEOC says, and it's interesting guidance, and I think it's an interesting concept and a useful concept. If an inquiry is not specifically disability related, and if it identifies non-medical reasons on the same level as medical reasons for an employee's absence, you can ask the question. So what does this mean? Let's take an example. You can send the following question to your employees. In the event our business reopens in the near future, would you be unable to come to work for reasons such as childcare being closed, public transportation being sporadic, or having a compromised immune system that makes you more susceptible to COVID? You see, by answering yes to this question, employees are not telling you, I have a compromised immune system. What they're telling you is, I might have childcare challenges, I might have transportation challenges, I might have a compromised immune system. And the EEOC says that is okay. Just note, if all of your employees drive to work, have kids in college, right, then you probably should not be asking this particular question because it will be obvious that anyone who says yes has a disability. So you need to tailor the question to your particular workplace, but you can tailor the question based on the principle that I've just explained. So with that, please feel free to send questions through the chat. I'll be glad to address them once everyone finishes, and I turn it over to Marlene. So thank you very much.
Thank you, Isaac. Next, we have Mark Papadopoulos. Mark has over 20 years of experience litigating cases and advising clients of various sizes on matters from the complex to the routine. Mark frequently provides advice and counsel to clients on matters such as internal complaint investigations, personnel policies, payroll compliance, employee disability and leave issues, and other human resources compliance matters. Mark's expertise in wage and hour stems from his 6-year tenure at the U.S. Department of Labor, during a period in which the Fair Labor Standards Act regulations and the Family and Medical Leave Act regulations and the Child Labor regulations were all written. From 2005 to 2008, he served as a senior policy advisor to the Assistant Secretary for Employment Standards, where he assisted on a full range of wage and hour matters, including federal rulemakings, legal guidance documents, such as wage and hour opinion letters, and the Field Operations Handbook, and overall enforcement policy. Wage and hour Mark will therefore be speaking to us on wage and hour considerations related to the coronavirus pandemic. Mark?
Thank you, Marlene. Yes, I'm going to speak a few minutes now about some wage and hour considerations related to the COVID-19 pandemic. With so much of society shut down, many employers are seeing a significant drop in revenue and, of course, are looking for some cost-saving measures. Options that you may be considering or have already considered are layoffs, furloughs, or reductions in employees' hours or pay. The simplest decision from an FLSA standpoint is to lay people off, lay employees off. And in a moment, my colleague Wendy Fishman is going to speak about some differences between layoffs and furloughs and some of the legal implications of that decision. But the wage and hour implications don't really kick in unless you consider that sort of middle ground route of furloughs or reductions in hours and pay. So let's consider some of those options and how to stay compliant with the wage and hour laws. Your most straightforward group of workers, if you're looking to reduce pay or hours and stay compliant with the law, is your hourly workers. Non-exempt hourly workers generally are only paid for the hours they work. So you could furlough those employees in part or in whole and only call them back when and in the manner you need them and pay them for the hours they work. Your tougher situation arises with your salaried exempt workforce, because salaried exempt employees must be paid on a salary basis, which means for any work week in which they perform any amount of work, they must receive the same predetermined guaranteed minimum salary of not less than $684 per week, irrespective of the quality or the quantity of the work performed. So the employee works a long week, gets the pay, works a short week, gets the pay, has a productive week, gets the salary, has an unproductive week, gets the salary. So at first blush, you might say, well, if I reduce hours, I still have to pay the same salary. Well, there are a couple options available to employers for their salaried exempt employees. The first is a prospective reduction in salary. That is, employers may reduce the salaries of one or more exempt employees with or without a corresponding reduction in hours. Now, you want to give some advance notice. You've got to give notice under the FLSA, at least in advance of the pay period in which the reduction is going to occur. Keep in mind also that there's no prorated minimum required salary amount. It's $684 per week. So if you have an employee making $800 per week on a 40-hour work week, and you reduce that employee to 20 hours per week and pay them $400 a week, that employee is non-exempt, entitled to overtime. Now, you may say to me, Mark, that I'm not worried about that employee incurring overtime liability. He or she's not working overtime. Nobody's working overtime. And that may be, and it may be a risk you're willing to live with. There's an additional risk, though, by reducing that level below the minimum required salary, that the employee may later argue that was indicative that he or she was never really exempt under the law, and therefore seek to go back into pay periods in the past or pay periods in the future where he or she has worked overtime and seek overtime compensation. That may still be a risk you're willing to live with in this environment, but it's a real risk. So how long does this prospective reduction in salary need to occur? Well, the Department of Labor Wage and Hour Division addressed this back in 2009 in some furlough FAQs, and they said that a reduction in salary can occur during an economic downturn, provided it is bona fide and is not used as a device to evade the salary requirements of the Act. It must be based on the long-term business needs of the employer, not the short-term, day-to-day, or week-to-week operating needs of the employer. Outside of this context of economic shutdown, the courts have generally ratified 3 months as a sufficient minimal period to change the salary of a salaried exempt employee on a continuous basis. So given all that, what do I advise my clients? I tell my clients that at the time you reduce that salaried exempt employee's pay, it should really be indefinite at the time you do it. That is, this is what we need to do right now to get through this period. And if and when business returns, we'll revisit it then. Now, it might be a month, might be 2 months, might be 6 months from now, but it's indefinite at the time we're doing. The second major option you have with your salaried exempt personnel is furloughs. And again, with furloughs, in order to remain exempt during a furlough, a salaried exempt employee must continue to be paid on a salary basis and must be paid for any week in which any amount of work was performed. So under those circumstances, the simplest option there is what I call no work, no pay. You tell the salaried exempt staff not to perform any work and you don't pay them for the week, but it really means don't perform any work. No emails, no logging on, no Zoom call, no nothing. Because a salaried exempt employee who performs any amount of work could trigger your obligation under the Act to pay the entire salary for the week. So as such, your furlough notice, any furlough notice that goes out in that regard, should include language that no work is authorized during the furlough period without express advance written approval. Your second option under furloughs for your salaried exempt employees is what I call no work, some pay. And it starts with the same basic premise. Again, absolutely no work can be performed for your salaried exempt personnel. But now you start to play with the employee's accrued paid leave a little bit. And your first sub option is no work, I don't owe you any money, but you permit the employees to use some form of their accrued paid leave to cover the unpaid absence. And they can do it in hourly increments, daily increments, weekly increments, because you have no obligation to pay. They're just covering over some of the act with their own accrued leave. The second sub option is, instead of permitting them to use the accrued paid leave, is the less popular option, of course, is mandating that they use their accrued paid leave, that they in essence burn down their leave in hours, in minutes, hours, or work week. Anyone looking to do that should really confirm under state law that that's also permissible. It is permissible under federal law. It's permissible under most states. I believe there's some states that put limits on the degree to which you can force employees to use their accrued paid leave. One final note on furloughs and exempt employees, and that is there's certain categories of employees that have no salary basis requirement, and that is lawyers, doctors, and outside sales employees. And so with that category of employees, you can really be more creative in terms of reducing hours or pay without running afoul of the act, without risking the exempt status of those employees, so long as they continue to perform exempt work. Thank you.
Great. Thank you, Mark. Our final panelist today, before we move to questions and answer session, is Wendy Fishman. Wendy advises for-profit and nonprofit employers on all aspects of the employment relationship. In addition to a long career in private practice, Wendy spent 5 years conducting internal investigations in-house at Fannie Mae. Wendy most enjoys getting to know her clients and their businesses and collaborating on practical solutions that help clients achieve their business goals while maintaining compliant, compassionate employment practices. As a member of the firm's COVID-19 task force, Wendy has been working with employers to pivot their workforces to teleworking environments, manage furloughs, layoffs, and salary reductions, and plan for returning employees to the workplace. Wendy will be speaking now on layoffs and furloughs, including the unemployment provisions of the CARES Act and implications for loan forgiveness under the Paycheck Protection Program. Wendy?
Thank you, Marlene. So Mark just spoke with you about the wage and hour law implications of furloughs, layoffs, and other payroll reduction efforts. And essentially, a furlough is an unpaid leave for a period of time. It's temporary, and employees stay employed during the furlough. A permanent layoff is generally an actual termination and usually is done for cost-cutting reasons. So now let's talk about how the stimulus relief available through the CARES Act, which is the Coronavirus Aid, Relief, and Economic Security Act of 2020, which passed at the end of last month, how that may affect your decisions about conducting furloughs and layoffs or reversing those actions if you've already taken them. The CARES Act offers relief in two key areas that I'm going to talk about today. One is through unemployment compensation benefits, and the other is through the Paycheck Protection Program, which offers low interest loans to small businesses, which in some cases can actually be converted into grants. Understanding these provisions can help you and may be able to inform your strategy in addition to some of the considerations that Mark discussed when you consider workforce reductions. So a key consideration that we should keep in mind is that for employees to access unemployment benefits, they have to stop working for you. That's sort of what unemployment means. It can be partially, it could be completely, it could be temporary, it can be permanently, but the key is that to some degree, they have to stop working for you. But to maximize the benefit to your company, if you're seeking or if you've already been awarded funding under the PPP, you most likely are going to have to retain your workforce at typical levels during the 8-week period after you've received your payment. So you can sort of see the tension between these two different programs. First, we're going to talk about unemployment. The CARES Act provides 3 significant types of unemployment compensation relief. First, it expands access to individuals who otherwise might not be eligible for benefits. Second, It provides an additional $600 in weekly benefits to everyone who qualifies. There are some limited exceptions for people who receive benefits under certain programs, but generally it's $600 to everybody. That benefit sunsets on July 31st of this year. Finally, the CARES Act extends the amount of time that a recipient can receive benefits by an additional 13 weeks. So typically, unemployment benefits would be available for 26 weeks. This extends it to 39 weeks, and that can continue through the end of this year. So the additional $600 is available during the entire period, both the first 26 weeks and the additional 13 weeks, but that $600 benefit will only be provided through July 31st, no matter how long the employee is receiving the benefits. So what does this mean for your planning? Well, one thing that you can keep in mind as a rule of thumb is that any employee who became eligible for unemployment benefits at any time on or after April 2nd will be able to get benefits through the end of this year. Some employees actually will earn more on unemployment than they would if they continue working for you. To figure out where the inflection point is in terms of whether they'll do better working for you or whether they get unemployment, that's going to vary and depend on your state's weekly benefit amount. But to take for an example, New York, there an employee who's earning about $50,000 a year will make about the same on unemployment as they would while they're employed. If you have an employee earning less than that, they actually are going to do better being on unemployment benefits. So if you're inclined to conduct layoffs or to furlough employees, you might want to consider how much unemployment an employee would collect, just as one of the factors in your selection decisions. But whether you conduct furloughs and layoffs at all and how quickly you try to restore your staffing levels also may depend on whether your business is receiving funds under the Paycheck Protection Program. So the whole point of the PPP is that it's intended to enable small businesses to maintain their headcount and their wages during this crisis, not for you to terminate or lay off or furlough people. If you receive PPP money, it's a loan that's basically at a low interest rate. You've got a 6-month deferment period before you have to start making payments, and it's payable in 2 years. But the most attractive feature of the PPP and what's gotten all the press is that there's an opportunity for loan forgiveness, which essentially turns all or a portion of your loan into a grant. The loan forgiveness period is the 8 weeks from the date that your business receives the loan funds. But there's a catch. Because the program's intended to help small businesses retain their workforces, recipients are expected to use the proceeds primarily to fund payroll expenses. So in general, you can only use PPP funds for certain purposes. You can use it for payroll costs primarily. You can also use it for mortgage interest payments, rent, utility payments, and interest payments. But if you want to be able to take advantage of the loan forgiveness feature, there are additional rules. So first, and probably the most critical to your determination of how layoffs and furloughs will impact your loan forgiveness ability, is that at least 75% of the money has to be used for eligible payroll expenses. Only 25% can be spent on the other types of expenses. In addition, there are ways that your loan forgiveness amount can be reduced. So if you reduce your number of full-time equivalent employees during the 8-week period of the loan, your loan forgiveness may be reduced. And there's a formula for calculating how significantly you'll lose loan forgiveness. It's not all or nothing. In general, it's based on comparing the average number of full-time equivalent employees that you have during the 8-week period compared to your average number of full-time equivalent employees during a comparison period. And there actually are 2 different periods. You get to choose the one that's more beneficial to you, which is nice. And for any of you who are seasonal employers, you should know that the Small Business Administration just issued some new guidance. I don't remember if it was today or yesterday, that gives you some additional flexibility. Now, finally, your loan forgiveness will be reduced for any employee earning less than $100,000 on an annual basis in 2019 if you have cut their salary during the 8-week period by more than 25%, as compared with their wages during the last quarter that was completed before you got your loan. So basically, you start with the assumption that you have full loan forgiveness, but that number is reduced and you have to pay back more of the loan by the factors that I just discussed. Are there steps that you can take to help get more loan forgiveness and take that level back up? Well, the primary way to do that is to bring back an equivalent number of full-time equivalent employees as those that you laid off or furloughed between February 15th and April 26th, and to do that by June 30th. That may enable you to reverse the hit to your loan forgiveness. It's more complicated than that, but that is a key consideration. You should note that it's full-time equivalent employees. They don't have to be the same employees or even the same positions as the ones that were previously eliminated. But if you reduce headcount and wages, both are going to have to be restored by June 30th. Keeping in mind, though, that you still have to maintain that 75-25 ratio. Another thing that you can consider is that when you make your cuts in the first place, look at your higher paid employees. You can make salary cuts to employees who are earning more than $100,000 a year, even more than the 25%, as long as you keep them above $100,000 without affecting your loan forgiveness at all. That might not make them too happy, but it is an option for you. The other thing you can do is look at 1099s. If you use freelancers, independent contractors, they're not factored in, and so you might want to look at cuts to those first if you haven't done so already. Now, ultimately, you might determine that it's just impossible for you to achieve your immediate existential cost-cutting objectives, which you need to do to keep your business afloat now, without sacrificing loan forgiveness. But keep in mind, it's also not all or nothing. You can get a fractional amount of loan forgiveness. And in the worst case, you've gotten a low interest loan with a 6-month deferment, and you have 2 years to pay it back when hopefully conditions will have improved considerably. So hopefully these ideas will help you as you approach layoff and furlough decisions. And I think now we can open it up for questions.
Great. Thank you, Wendy. Yes, so I think the first question that we have received from the webinar participants is probably for Catherine. It is, we received a resignation on Friday from an employee stating she was not able to return to work due to not having childcare because of COVID-19. Can we just accept her resignation, or does this fall under the new family extended leave law where she would be eligible to receive 2/3 of her regular rate of pay up to 12 weeks? Catherine?
Thanks. Thanks, Marlene, and thanks for this good question. So you should not just accept her resignation in this scenario, because the federal law provides employees with paid leave for the very reasons specified in the question. If the employer has fewer than 500 employees, then this situation falls under both emergency paid sick leave and expanded family and medical leave. And you should inform the employee that she qualifies for these types of paid leave. If she's a full-time employee, she can receive 80 hours of emergency paid sick leave, paid at 2/3 of her regular rate of pay, with those payment caps that I mentioned before, $200 a day and $2,000 total. And then after those 2 weeks, and assuming that the employee worked at least 30 days prior, she would be eligible for expanded family and medical leave that can cover 10 more weeks at 2/3 of her regular rate of pay with those payment caps. However, each circumstance really needs to be evaluated with a case-by-case and fact-specific analysis. For example, to see whether an employee may have already exhausted his or her FMLA leave. If an eligible employee has already taken some FMLA leave for traditionally qualifying reasons during the 12-month period, the eligible employee may still take up the remaining portion of the 12 weeks with expanded family and medical leave. But if an eligible employee has already taken the full 12 work weeks of FMLA leave during the 12-month period, then the eligible employee may not take expanded family and medical leave. So it really is a very fact-specific kind of inquiry.
Okay, great. Thanks, Catherine. The next question is probably for Isaac, and then maybe also some Catherine. What are the common business and legal approaches to dealing with the situation of an employee classified as an essential worker who does not want to come in and or have run out of sick vacation days?
Thank you, Marlene. We received this question prior to the webinar, so I had the benefit of sort of being able to think about it a little bit. A slightly modified version of this question, I will answer that question directly, and I will also give a slightly modified version that others are asking. What if an employee is scared to come in? They just contact you and they say, look, I'm afraid. For whatever reason, I'm scared to come in. So in many respects, it's the exact same analysis. The employer should begin by understanding what is the reason for this request. Is the worker afraid to come in due to a disability? Is the worker refusing to come in due to a disability? So the EEOC makes clear that employers are still obligated to provide accommodations during a pandemic. So they specifically give the example of people with chronic lung disease, people with heart conditions, compromised immune systems. They are at much higher risk of complications due to COVID than, of course, the general population. So if the employer determines that the reason for the request is a disability, then the question becomes whether the employee can perform the essential functions of the job from home. Now, let's assume it's definitely not possible. Let's assume that they cannot perform the essential functions from home. They must come in. Then the question becomes, can the employer take some simple measures in the workplace that will protect this employee and enable them to feel comfortable coming in, and the accommodation will be steps taken in the workplace rather than having to allow the person to stay home. The EEOC gives a few specific examples, designated one-way aisles, using plexiglass or other barriers to separate employees from customers. There are many things that can be done depending on the workplace, but perhaps following a conversation with the employee, these measures will put the employee's mind at ease. Now look, let's assume the reason is not a disability. Let's assume that just the employee, for whatever reason, not disability related, is scared to come in and refuses to come in due to COVID. There's no legal obligation on your part, but I want to observe that sometimes the legal answer should not be the deciding factor. It's shocking that I would say this as a lawyer, but sometimes the legal answer should not be the deciding factor in the employer's response. Although the employer may not have a legal obligation, from the standpoint of employee relations, it just might be the right thing to do. It might be a good practice to allow an employee, if it's possible for the employer, to take temporary leave if they're afraid to come in. So let's take the example of an older worker who's afraid to come in. They say, look, due to my age, I'm especially susceptible to complications due to COVID. Please don't make me come in. Okay, now, purely from a legal standpoint, the EEOC has explained that the Age Discrimination in Employment Act does not have an accommodation provision like the Americans with Disabilities Act. So based on age alone, the employer has no legal obligation to say, fine, you don't have to come in. But again, we need to separate the legal answer from the right business decision. Whenever impossible, I encourage employers to treat employees with compassion, with understanding, to try to understand their circumstances, and to be as flexible as possible in response to requests from vulnerable employees. And look, sometimes it's not possible. Sometimes just for various business reasons, you need someone to come in. And if they can't come in, you need somebody else in their place. But if that's not the case, my advice is always be flexible, help people when possible, and that will, in the long run, lead to more loyal employees. It will lead to a happier workplace, and just in general, it's the right thing to do. With that, I pass it over to Kat.
Thanks, Isaac. So from the perspective of the leave laws and the FFCRA, we would also, similar to Isaac's first question, we would need to know why the employee does not want to come in. And is it for a qualifying reason under the FFCRA? If the employee has a qualifying reason, then the next question is whether the employee is exempt as a healthcare provider or emergency responder. But these exemptions are supposed to be used judiciously. So the way this original question was worded, it was employee classified as an essential worker. And so We don't know exactly what that means and what definition is being used, but you need to look at the definitions in the FFCRA to see whether those people are exempt from the leave requirements. In general, a healthcare provider is anybody employed in a doctor's office, hospital, healthcare center, clinic, post-secondary educational institution offering healthcare, instruction, retirement facilities, etc. And this also covers individuals who are employed by entities that have contracts with any of these types of institutions to provide those healthcare services. It also includes entities that provide medical services or produce medical products related to testing or drugs, vaccines, diagnostic materials, etc. An emergency responder is anybody necessary for the provision of transport care, healthcare, comfort, nutrition, law enforcement, firefighters, emergency medical services, etc. So those kinds of people are all can be exempt. It should be analyzed on a case-by-case basis again, but from those federal leave laws. If the employee has a qualifying reason and is not exempt, then the employer should inform the employee that leave under the FFCRA is available. We did have a sort of corollary question to this, which is what if the employer wants the employee to stay home? It's not the employee who's scared, but the employer knows that the employee has somebody who's sick at home, and they want to tell the employee to stay out of the workplace. And if the employee can't telework, and telework is an option for many types of businesses to allow somebody to continue working. But if that's not an option, then with respect to the leave laws, the analysis is very much the same, which is, does this fit into a qualifying reason? Now, sometimes in some circumstances, if there's a person at home who's sick with COVID-19, other people in the house may be required to quarantine as well. So you need to look at the specific state laws and the quarantine orders and that kind of thing to know whether that falls under it. If there isn't a qualifying reason under the law, that doesn't preclude the employer from telling the employee to stay home, either on a paid basis if the employer wants to do that, or an unpaid basis. But it's important to remember that for purposes of the tax credits, you have to really make sure that you're fitting within a qualifying reason.
Great. Thank you, Isaac and Catherine. The next question that came in is for Mark. Do we need to compensate employees for time spent waiting in line to get their temperature taken before entering the workplace?
Yes, good question, and a question I have been receiving, and it could be in the future of a lot of employers. The short answer is, for exempt employees, no, that's part of their salary. For non-exempt employees, I'm advising clients, you should pay for that time. A little bit of background, under the FLSA, generally you only need to pay employees starting with their first principal activity of the day, and activities that are preliminary or post-preliminary to that activity are not compensable. So you get up in the morning, you shower, you change, maybe you drive into work, back when people drove into work. Those things all feel like they're part of the workday, but they're classic preliminary activities that are not compensable. But over the years, the courts have taken certain preliminary and post-preliminary activities and deemed them to be integral and indispensable to the principal activity of the day. In the meatpacking industry, the acts of donning and doffing personal protective gear, leggings, hard hats, that sort of thing that they stored at the facility, the Supreme Court there said that was intrinsic or unique to the bagging and cutting of meat, such that it was compensable, it was directly related to your work. On the other side of the spectrum, there was an Amazon case, some of you may remember back in 2014, where Amazon was screening employees leaving a warehouse, and those lines could last up to 25 minutes or so. And the Supreme Court there said that the screening of employees was not related to the work the employee's performing. Screening for theft is unrelated to the retrieving of packages for shipment, and that time was not compensable. My own personal view is that temperature checks are closer to the Amazon case. They're across a broad range of industries. They're not intrinsic to your workforce. But I'm still telling people to pay the time because for a host of reasons. One is it's a close call. Two, state laws are broader on this issue. Even that Amazon case came out differently under state law in terms of what is compensable work. 3, I don't know how the enforcement agencies are going to react to this. And finally, hopefully these lines are going to be very short and it's just going to be a couple minutes and it's just going to be non-exempt employees.
Great, thank you, Mark. We have time for one more question. This question came in, I believe, for Wendy. Can our employees get unemployment benefits if we reduce hours instead of conducting furloughs or layoffs?
Thanks. So generally, yes. Employees whose hours have been reduced generally can get unemployment benefits to make up the difference of that time that they're missing. However, there's a really important caveat here. You want to make sure that the amount that they earn from working part-time doesn't exceed the weekly benefit amount that would be available in the relevant state under their unemployment compensation benefits if your goal is to help the employee get maximum unemployment benefits. And the reason for that is that in order for employees to be eligible for that additional $600 per week under the CARES Act, they need to earn at least $1 of unemployment benefits, or at least that's how most lawyers are sort of interpreting the way that the CARES Act provision is written. So it's best to keep their compensation under your state's weekly benefit amount so you can help out the employee in that way. The other thing I would say, though, is that your company, if this is what they're considering doing, might be a good candidate for work sharing or short-time compensation programs. That's a whole other program that has been available for some time. The CARES Act has sort of stepped it up. About half of states, a little more than half of states participate in these programs, and they're basically designed to help avoid layoffs and furloughs. The way it works is essentially the employer continues to employ the employees part-time, and it's pursuant to a whole plan. And if you can show that in order to avoid laying people off, you will continue to employ them but at reduced hours, then if the state participates, they will make up the difference. Under the CARES Act, there is an opportunity for additional funds here. So even for states that don't participate, the state will essentially be reimbursed for half the cost of the work share benefit and the employer pays the other half. It's a little bit more complicated because you do have to submit a plan and get it approved, but it can be a good option. And the main thing that you would need to be able to show is that you're doing it in order to avoid layoffs, and that without doing it, you would be planning to lay off those people.
Okay, thank you. So thank you very much today to our 4 panelists and also all the participants who came to our webinar today. In closing, I'd just like to say, as you face these unprecedented challenges during the global pandemic, we remain available to assist you. In addition to the webinar today, we've created a COVID-19 resource center on our website, potomaclaw.com, which has many articles written by our lawyers on different aspects of managing the crisis. And of course, we're always here to talk with you. Be well.